Yes, I can now. I can now. Nice to
Fantastic.
see you and the audience there in Nigeria.
Fantastic. Over to you.
Thank you very much for the introduction. And yes, we can see now the room. And welcome to this last session of today. My name is Renato Nazzini. I am a professor at King's College London. I'm the director of the Centre of Construction Law and Dispute Resolution, and I act as arbitrator and also as counsel in international arbitration. So it's a great pleasure to join you virtually. It would have been even more of a pleasure to be there in person, but that wasn't going to be this year. I hope that on future occasions, for future conferences, we will be able to meet properly. So the last session of today is an Oxford-style debate in which we are going to discuss or debate, rather, the following motion. Are specialized construction courts better suited for resolving African construction disputes as compared to arbitration? And I am joined this evening to debate this motion by Daniel Tivadar and Funke Adekoya SAN. So let me introduce Daniel first, because Daniel will argue in favor of the motion and will go therefore first, and then Funke will argue against the motion and therefore will go, of course, second. And there will be then time for questions for you. So the way it works, just in case you may not be fully familiar with the format which we are using. So we have this motion that I have just read out. Then Daniel will argue in favor of the motion for about 15 minutes. Funke will argue against the motion for about 15 minutes. Then both Daniel and Funke, of course, will have 5 minutes in rebuttal, and then we'll open up for questions to you. So please ask the advocates tonight any questions you may have on the topic, on the motion. Then both advocates will have a very short time for conclusion, and there will be voting and announcement of results at the end. So first of all, Daniel Tivadar is a barrister and an advocate both in England and Wales and in Zimbabwe, so he's dually qualified. His practice focuses on commercial litigation and both domestic and international commercial arbitration, with particular emphasis on construction disputes, especially in the past few years. Great experience also sitting as an arbitrator, and of course appearing before International Arbitration Tribunal. In terms of appointments, Daniel is regularly appointed in LCIA, AFCA, and Commercial Arbitration Center proceedings. He was educated at Cambridge and Oxford, and after having practiced for a substantial period in London, has moved in 2013 to Zimbabwe, where he has a very international practice. Funke Adekoya SAN is now an independent arbitrator and litigation consultant, also with a focus on commercial disputes and disputes concerning infrastructure, energy, natural resources, oil and gas, and construction. She's a chartered arbitrator of the CIARB, of the Chartered Institute of Arbitrators, and she appears as counsel as well as acting as party appointed arbitrator, sole arbitrator, or chair of tribunals under several rules. She has also provided expert witness evidence on Nigerian law in England, in the United States, in Turkey, and in Italy as well. So I will now hand over to Daniel to argue in favor of the motion. Daniel, over to you.
Thank you very much, Professor Nazzini, and thank you very much to the ACL for the very kind invitation for this debate. We've just heard the motion, which I will be arguing in favor of. But first of all, I wanted to note that the motion itself has numerous components, and there's one component in particular in the motion that I wish to address right at the outset. And that is that what we are debating today is whether specialized courts are more suited for construction disputes than arbitration tribunals in Africa. And it is this term, whether it is more suited, that I would like to just dissect a little bit. First of all, it is not part of my case that arbitration should not be used as an alternative to court litigation. It is undisputable that in certain circumstances, arbitration is a very valid and preferable method of resolving disputes. What my argument is that if one compares arbitration and court litigation, both in points of principle as well as in terms of practicalities, it is clear, I would argue, that specialized courts are better suited to resolving all disputes that can arise in a construction project setting. When I discuss whether one method of dispute resolution is more suitable than the other, I will be focusing on three particular aspects in which a dispute resolution venue may or may not be more suitable than the other. The first one is that I say that the method that is more suitable is the one that consistently produces determinations that are consistent with each other. In other words, eliminates the risk of inconsistent and contradictory findings and determinations. And I say that only court resolution of disputes can do that, arbitrations can't. The second point I will be examining are more practical requirements. And I say that the method of dispute resolution that satisfies requirements of transparency, independence, and expertise of the decision maker is the one that is more suitable. And I will be saying that that is the courts, specialized courts, rather than arbitral tribunals. And finally, I will be examining, I argue that this question of which method of dispute resolution is more suitable shouldn't only be looked at through the prism of what the parties want. I would argue that there are more broader considerations that have to be taken into account, such as the development of law, the clarification of the law, and capacity building, which I just heard in the previous speech as well. The previous topic in relation to experts was something that was discussed. And I say that once again, it is the courts, the specialized courts, that can satisfy the demands the arbitral tribunals can't. So let me turn to those three arguments. I think that is all that I have time for in my first 15 minutes. So starting with the consistency of determination. It is the most trite proposition so far as arbitration is concerned, that the arbitral tribunal's jurisdiction arises only by virtue of the consent of the parties. It is only out of that consent that the tribunal has any jurisdiction to determine their dispute. Now, that consideration, of course, does not apply in a court setting. A court will have jurisdiction or won't have jurisdiction by operation of law. So irrespective of what the parties want or consent to, the court will have jurisdiction over their dispute if it falls within the court's jurisdiction. And I say that that fundamental difference between arbitration and court litigation gives rise to an inherent and unavoidable limitation so far as arbitration proceedings are concerned. And the best example that one can think of is multi-party arbitrations. So one can envisage a situation where we have a claimant and a defendant, both of whom agree that it would be in their interest, as well as in the interest of justice, to include a third party, so for a third party to be joined to those proceedings, or in the alternative, for other proceedings that are already ongoing to be consolidated into the same arbitral proceedings that this claimant and defendant are currently having. We can even envisage that the tribunal would agree with that. So the tribunal agrees and the parties agree, everyone in the room agrees, that it is in the interest of justice for a party to be joined, for proceedings to be consolidated. That, however, cannot be achieved in the arbitration setting unless that third party consents to the tribunal's jurisdiction being extended to that. Now, the same consideration, of course, doesn't apply in courts, because the courts, typically what they will examine is it in the interest of the third party to be joined, and is it in the interest of justice for the third party to be joined? And if the answer is yes to these questions, then most court rules will enable the court to exercise its jurisdiction and its case management powers and either consolidate proceedings or join the third party. Now, multi-party disputes are not the exception so far as construction disputes are concerned. They are actually the norm. Construction projects and major construction projects, which are, of course, the ones that this conference is addressing, by their very nature, always involve numerous dozens, hundreds of parties acting on the same project, both in terms of financing, in terms of insurance, insuring the project, but most importantly, in terms of performing the project. So it is not uncommon for there to be an employer, a main contractor, and then hundreds of subcontractors, vendors, suppliers, and so on, all of whom are performing on the same construction project. And it is inevitable that in these hundreds of relationships, there will be several disputes that arise. And what I am emphasizing is that these disputes almost never arise in isolation from one another. They are inextricably intertwined with one another. And one example of that would be the most common dispute that we seem to be having on construction disputes, which relates to delay. So if we imagine a scenario where the contractor, the main contractor and the employer are having a debate about whether delay was caused at project level, and that issue is decided by an arbitral tribunal, i.e. we now have a decision on the project critical path. That finding of the project critical path is going to inform the main contractor as to which subcontractors or vendors or suppliers it may wish to pursue for contribution to the losses. However, the finding that the tribunal has made on this most crucial, critical component of the case, i.e. criticality at the project level, is not something that's even admissible in subsequent arbitration proceedings, and it certainly is not binding. So that is just one demonstration where, at best, what we have is that the same argument has to be repeated at great cost and loss of time, but at worst what we have is numerous inconsistent results, determinations being handed down by arbitral tribunals. And so my first point, which is a point in principle, it's not a point that addresses practicalities of litigation versus practicalities of arbitration. My first point of principle is that I argue that a system that contains an inherent and unavoidable risk of inconsistent and conflicting determinations cannot be the most suitable system for the resolution of disputes. Turning to my second argument, and I don't wish to shy away from the practicalities of litigation versus arbitration, and this is really the topic where people in favor of arbitration tend to focus their attack on the court system. But let us examine the typical arguments that are made. Let us compare a judge to the function of and the office of an arbitrator. The starting point, I argue, is that a judge is an individual who has made a career out of dispute resolution. And the judge sitting in a specialized court, and a court that is specialized in technology and construction issues, as we're currently debating, is a judge that every single day is dealing with construction-related disputes. These are not individuals who dabble in this area. These are individuals who are specialists, who have the highest amount of experience that any individual can obtain by virtue of doing it all day. If we compare that to the typical arbitrator and even international arbitrator, what we tend to find, what happens in practice, is that arbitrators typically come from private practice, and they are trying to balance the demands of private practice with the demands of resolution of disputes. And whilst the reality is that every single institutional rule that I know will emphasize that the arbitration has to be conducted in a way that is expeditious and cost-effective. And that is a given. It's contained, if not in those words, but words similar to that in every single set of rules. The reality, however, is very different. And anyone who has tried to list, let's say, 2 or 3 week hearing before an arbitrator will realize that that is the case, because it is once the arbitrator takes his or her diary out and we try and find a suitable date, that suddenly the expeditious disposal of the matter sort of goes out the window. And the matter is made, of course, even worse when we're dealing with a tribunal of 3 arbitrators. The other issue I wanted to address is the independence of arbitrators and judges. Now, judges are in no way dependent on the parties appointing them for their next dispute, because the cases are just allocated by the court service, and frankly, judges don't care whether parties like them or don't like them. They are there to do their job, and that is what they do. Well, that stands in sharp contrast to how arbitrators are appointed and how arbitrators function. Arbitrators are, of course, very much there on the esteem in which other lawyers hold them. And if one examines the way that arbitrators are appointed, I would argue that also gives rise to concerns about their independence. If we look at the 2 ways that arbitrators are typically appointed, the first one is that an arbitrator can be party appointed. And this, again, we all accept, because we act in arbitrations, and we act in arbitrations if we are in construction disputes. Very often there will be 3 arbitrators on the panel. Very often it is our client who appoints one, the other side that can appoint one, and the third person typically is appointed by an institution or agreed to by the other 2 arbitrators. But the reason why we sort of consider this to be an acceptable way of appointing an arbitrator is because we're used to it. And I would encourage all of you to take a step back and actually think about what is happening here, because I say that in no other area of the law would we accept a situation where a party can have an input into the identity of the decision maker in their own cause. So you would never accept a situation where a person who stands accused of a crime can say, well, I have a preference for Mrs. Justice so-and-so over Mr. Justice so-and-so. And there's a very good reason why we don't accept that. The reason why we don't accept that is because we assume, correctly in my view, that the accused or the party will be acting in their own self-interest rather than in the interest of justice. And I argue that that situation is exactly the same in the arbitration context as well. So the party appointment of arbitrators, I argue, is not something that should give us comfort as to the independence of the arbitrators. Now, whilst I say that the appointment of arbitrators by parties is somewhat surprising, I would say that the appointment of parties by a third-party institution is mysterious. This is once again an argument that is often raised, that institutions appointing arbitrators will of course appoint the arbitrator that is best suited for the dispute. I have a question why that would be the case. The reality is that a party or the party's representative has no idea why an arbitrator was appointed to hear that dispute. There is simply no evidence that we have that would enable us to decide that this is the best arbitrator. Yes, sometimes the panel of arbitrators is available. How exactly one makes it onto the panel, once again, is not as clear as the transparent procedure in which most countries will appoint their judges. So in terms of independence, I would respectfully argue judges are more independent and their appointment more transparent than arbitrators. And finally, I come to what I say is the most important point, and the point that leads me on to my final argument in a few moments, and that is this. The way that a judge conducts a hearing can, of course, be publicly scrutinized. The reason being that judges sit in public. It's only in exceptional circumstances, typically when third-party rights are involved, so family settings and so on, where judges will not sit in public. Also, the determinations that judges reach, i.e. their judgments, are available to the public and can be scrutinized. They can be scrutinized by other judges, by lawyers, by academics, and perhaps most importantly, by the construction industry itself. If we compare that to an arbitrator's award or a tribunal's award, tribunal's awards are, of course, not available in public. They are only available and they are only drafted for the purposes of the parties. And as a result, their quality can be significantly worse. And that's not a criticism of tribunals. It's a byproduct of the fact that the award is written only for the purposes of parties who know their own cases very well, unlike judges who, of course, draft their judgments for the purposes of the public, for the benefit of the public as a whole. And it is this point that brings me on to my last argument, and an argument that I say applies very much in the African context, which is, of course, part of the motion that we're debating today. I would argue that for the African construction industry to develop, and as well as all the support services, such as lawyers, such as experts, and so on, for that to develop, what we need and what the industry needs, the construction industry needs, is clarity as to the law. So they need the interpretation of the law that is publicly available and is binding, because that is how they can ensure that they can take fully informed decisions. And secondly, they need to ensure that the law is not static, but is constantly developing. Now, both of those requirements can only be achieved through judgments of courts. And if we want to ensure that the construction industry develops as it should on this continent, and all the signs are there that there's certainly a huge need for major construction projects to be undertaken on this continent. I say what the continent needs to do and the various countries need to consider is the same capacity building that you were looking at in the context of experts in the previous talk. We need to ensure that we have decisions that are publicly available, that are binding, and whose points can be applied and will be applied by subsequent decision takers. The point I wish to finish on is that the reality of the way construction dispute resolution is going is that there are an increased number of specialized courts. Of course, we start with the TCC in London. That is something that has been around under different guises and names since the 19th century. So it's got a history of about 150 years. But what is even more telling and perhaps more important are the recent developments that we have seen in Singapore, in Hong Kong, in Dubai, in certain states of Australia, all of whom have decided to adopt a specialized court process that is now competing and has a hugely growing caseload. And what we tend to do as practitioners, myself included, in fully African arbitrations, is that we look at, or disputes, is that we look at the guidance that is provided by these specialized courts given abroad. At the moment, it's typically the TCC in London, but I have no doubt that in a few years' time, we will be looking to those newly established courts from the other jurisdictions that I've mentioned. And I say, and I argue, that there is no reason in principle why the quality of justice that is dispensed by these specialized courts sitting in other continents cannot be achieved in Africa. There is no reason for that. And I say, fully accept that it is going to take time. It is going to take some investment in terms of the technology and the training of the judges. And it will take some planning in terms of what rules, particularly the specialized courts, should adopt. Nonetheless, I argue that that is time and money that would be well spent. Professor Nazzini, I think that is my 15 minutes, and I look forward to my learned colleagues' arguments. Thank you.
Thank you very much, Mr. Tivadar, for your submissions. And then I turn to Ms. Adekoya, SAN, Funke. Over to you, please.
Thank you very much, Professor. I'd also like to thank the organizers of this conference for inviting me to participate in this debate. I am speaking from the perspective and arguing that specialized construction courts are not better suited for resolving African construction disputes as compared to arbitration. And I'm going to follow the trend of argument that Daniel has put forward. I'm also going to start by highlighting the words better suited in the heading of the motion. And I'm going to put forward 3 points as well. The first thing I'd like us to consider is what is different about African construction disputes that results in construction courts being better suited. If a construction court in the fashion of the TCC is better suited for resolving construction disputes, then they're better suited anywhere in the world, whether it is in Africa or anywhere else. So is there anything peculiar which distinguishes the African construction dispute? I would say that there is nothing peculiar. The first thing that I'd like to say, my first point, is that all disputes involve fact witnesses and expert witnesses. And as we see from the previous session, there seems to be some perception that there's a lack of technical expertise on the African continent. And one of the speakers actually did indicate that there's no lack of technical expertise on the African continent. So if there's no lack of technical expertise, then obviously that technical expertise would be available at the adjudicatory level. So how will those specialized construction courts solve this problem? If you have the technical expertise available to adjudicate, they're available as well to adjudicate as arbitrators. They don't have to be part of a TCC system as operates in the United Kingdom. Arbitration allows parties to source their adjudicator, not just from Africa, but from anywhere in the world. And therefore, in my view, arbitration is better suited to resolving construction disputes than a technology court where you're restricted to the panel of judges who are posted to that court system or that court circuit. Because the technical experts exist in Africa, as has been said, there is no argument that African arbitrators cannot properly adjudicate over technology disputes, and that therefore there's a need for a specialized technology court where that expertise will be made available through the adjudication process. The second point that I'd like to make is that, assuming for the purposes of argument that we do appoint these technical experts as judges sitting in our construction courts in African countries, who owns the court and who funds the court? And I say this because one of the reasons why disputes, especially in the construction sector, go to arbitration is because in many instances, these disputes either involve a government agency or they involve a government itself. And therefore, at the time of entering into the construction contract, the employer and the contractor both agree, probably from the point of view of the contractor, who does not want to have any dispute resolved in the courts of the employer, where perhaps he or it may not be fully conversant with the system of governance in the employer's country. And so they opt for arbitration in the first place. Now, if we then say that technology courts or construction courts are better suited to African construction disputes, I would tend to believe that the first people who would oppose going to a technology court would be the contractors, who would be forced, in essence, to take the disputes arising out of contracts they have entered into, infrastructure contracts, or other government-funded contracts before the courts of the employer that they had wished to avoid by going to arbitration in the first place. The second aspect of that position, and why I think that technology courts are not better suited to resolving African disputes, is who owns the court. Obviously, we've agreed that the technology court will be part of a state court system. It's not going to be individually established. And therefore, the second part of that argument will then be who would pay the adjudicator. Obviously, they would be paid by the state. And there was one argument that ensures that unlike arbitrators who may be looking for their next appointment, and therefore, even though they are independent and impartial, they may be favorably disposed to the position put forward by the party that has appointed them. That when you go to a technology or a construction court where the adjudicator is paid by a totally neutral body, that is the state, assuming that the state is not also a party to the dispute, that one would then be assured that whatever decision comes down is a decision that would be satisfactory to both parties. But coming back to the last panel, where it has been agreed that there is sufficient technical expertise on the African continent, would those technical experts give up their roles acting as experts in the private capacity to take up judicial appointment in these technology courts, where the likelihood is that their remuneration would not be at the level of the remuneration they obtain from providing private technical expertise to parties who are disputants? I say this because in most African countries, the court system or the judicial system is seen as a social service. And therefore, the chances that a technology court or a construction court would have a higher pay grade that would be able to attract the level of expertise that is available for appointment as arbitrators in private disputes, I think is a pipe dream. And so even if for any reason countries did agree to have specialized construction courts, I am very unsure whether the quality of the adjudication that would come out of those courts would be at the level of the determinations that would come out of arbitration disputes. And then that then takes me to the point that Daniel had made about judgments from technology and construction courts being public, and therefore providing some level of precedence or guidance. But if the quality of the adjudication coming out of those courts is not at the level of the private awards that would be issued by arbitrators who are paid by the parties, then I would want to believe that in actual fact, we may not have achieved the proposed objective by appointing, setting up technology courts, which would belong to the state. The other point and the final point that I'd like to make is even if there was a possibility that technical expertise, African technical expertise is available for appointment as judges in African technology and construction courts, then it removes them from the pool of expertise that is available to the private disputants who take their matters before arbitration panels. There are two answers to that question. The first thing is that if private African expertise join the courts proposed to be set up as technology courts, would they be joining on a full-time basis, which means they are permanently removed from the pool of expertise that is available? Or would they be appointed for a tenure, which means that they would be permanently removed, but only for a period of time? And if they're removed only for a period of time, then there's a huge potential that after a 3-year or a 5-year tenure of service, sitting as a technology judge or a construction judge in the judicial system of a country, there's a high likelihood that if they are then approached in terms of disputes for appointment as technical experts, they may actually find that they have been conflicted either by decisions that they have taken or by parties who have appeared before them while sitting as construction judges. And that this will actually detract from the pool of technical expertise that is presently available on the continent and which still needs to be further developed. So all in all, my position would be that as we are growing the market for resolving construction disputes on the African continent, arbitration is still better suited to resolving these disputes than technology and construction courts, which will belong to the states, be set up by the state, be funded by the state, may not in fact therefore be of interest to private sector disputants, will draw away from the pool of expertise that is currently available and needs to be further grown on the African continent. And therefore, I ask you to agree with me that within the context of the present state of construction law and construction development on the African continent, arbitration is better suited to resolving those disputes than construction courts. Thank you, Professor, and I will add some further points during the rebuttal.
Thank you very much, Ms. Adekoya. Then, following our procedural timetable, I would ask Mr. Tivadar to proceed with his rebuttal, keeping to the time of 5 minutes. Thank you.
Yes, thank you very much. And thank you to Funke for very interesting arguments. Let me try and deal with them. I don't think I will have time to deal with every single one of them. But the one point that I certainly agree with is that what I said was described as, or rather the motion itself was described as a pipe dream. I wouldn't call it a pipe dream, but I would certainly call it a dream. And I think that is exactly where I finished off with my arguments. I readily accept that a huge amount of investment is needed for specialized courts to become a reality in Africa. I think that's that goes without saying. We don't have anything like that on the continent. Where I would disagree with the arguments that were made is that in of itself should be what stops the continent or certain larger economies of the continent from adopting these specialized courts. If specialized courts are better suited to resolving construction disputes on this continent, then we should certainly take steps to achieve them, rather than saying, well, how could we possibly get there given where we are at now? That would be, in my view, an incorrect approach to take. So I readily accept that a lot of investment is needed. Nonetheless, that shouldn't stop us taking steps in the right direction. The second point I wish to make is that I see the arguments against the motion as proceeding from the premise that one can separate courts and arbitration. And this is, I think, what the main thrust of the argument was, that we're talking about two separate pools of talent. That's not the case at all. Arbitration and the court system are, of course, interdependent. Arbitrations cannot exist in a vacuum. And for arbitrations to be effective, two things are needed. Firstly, enabling legislation, which by and large African countries have adopted. The model law has been adopted in numerous jurisdictions on the continent. But what is also needed is the court service itself, and it is needed to assist the arbitration process, so by way of interim measures, by way of discovery, compulsion of witnesses, and so on. There are many ways in which the court service can assist the arbitration, and also by the recognition and enforcement of arbitral awards. So we cannot separate these two systems. And what I am saying is that we have to make the court system sufficiently robust and technically sufficiently advanced in order to fulfill those roles in any event. So the development of the courts will have to happen, even if I'm wrong in my argument and arbitrations are better suited to resolving disputes. Even in those circumstances, the court service would have to develop, because without the court service, without the enforcement powers, and powers of essentially mandamus of compelling individuals and companies to do things, the arbitration process itself cannot work. So all those arguments that were mounted against me by saying this is very difficult to achieve, how will you pay the judges, and so on, all those arguments are self-defeating, because if we cannot get a sufficiently robust court service, then we are not going to have a sufficiently robust arbitration regime either, or reality of arbitration dispute resolution on the continent in any event. And then finally, I just wanted to return to the first 2 points that were made against the motion. And the first one was, if specialized courts are so good, essentially the argument went, why aren't they adopted in other countries in the world? Well, the reality is they are being adopted in other jurisdictions and in very developed jurisdictions. And that is exactly what I emphasized the first time round, that if we look at England has, of course, has had it for hundreds of years, or over 100 years. But if we look at newer adoptions, such as Singapore, Dubai, Hong Kong, Australia, even Germany, I think, has construction chambers now within their court system. That is the general trend. So once again, the argument sort of destroys itself, because it is on the premise that these courts are not being adopted. They are being adopted. And then the second point that was made, if I may just deal with that last, is that arbitration allows the sourcing of arbitrators from all over the world, as opposed to the courts where the argument went, the parties are restricted to the judges who are sitting on that court. Well, let us just remind ourselves about the quality of the judges, the sort of judges that parties may encounter when they go to the TCC. This is a court that had people such as Lord Dyson, Justice Aikenhead, Justice Edward Stewart, Sir Vivian Ramsey, incredible leaders within this area. So with respect, when the argument is made that parties are restricted to these individuals, well, they are very good individuals to be restricted to. Where there hasn't been an answer is the argument that I made, which is, how do we know the quality of the panel on an arbitration institution? And secondly, how do we know of the basis on which those arbitrators then are appointed or allocated to arbitration disputes?
Thank you.
So I think those are my 5 minutes. Thank you very much.
Thank you very much, Mr. Tivadar. And now over to you, Ms. Adekoya, for your rebuttal, also limited to 5 minutes.
Thank you very much, Professor. When Daniel was making his substantive argument in support of the motion, he made mention of the fact that the technology and construction courts, the decisions, the judgments that come out are public, provide guidance, and in essence, he argued for the development of construction law by way of a doctrine of precedent. And what I would like to say, and that this is the reason why the establishment of this type of court is better suited than arbitration for African disputes. And what I would like to say in rebuttal is that we need also to remember that when parties decide whether or not to put arbitration clauses in their contracts, they're very much aware that there are two twin parallel systems: the system of private dispute resolution by way of arbitration, and the public system by way of adjudication, which either went direct to the courts, or now in those countries where technology and construction courts are being established, they would go to those specialized courts. But parties opt for arbitration mainly because they want the privacy and the confidentiality that follows the arbitration process. And so when they weigh the options as to whether to take their disputes to a public arena where there's an opportunity for creating a precedent, they would rather opt for a private resolution because of the confidentiality that covers the dispute, and the fact that whilst arbitration proceedings are pending, there's greater likelihood that the parties can still work together, it being a less antagonistic proceeding than going straight into court. The second point that Daniel made in support of the establishment of construction and technology courts was that the fact that it would be maybe difficult to start, maybe more expensive, is not in itself the reason for not doing it, if that is the correct thing to do. And the point I would make in rebuttal to that argument is that it doesn't matter how much money the government or a state government that sets up a technology court puts into the system in establishing the courts, in staffing the courts. If those who you want to take your disputes to the courts, especially the international disputes, will be wary of going to the domestic courts because they really do not want to be involved in a public dispute resolution system. Thank you very much, Prof.
Thank you very much, Ms. Adekoya. You were slightly under your time, actually, so thank you for that, because that means we have more time for questions from the audience, that is. So I think you can type your questions in the chat, and I don't know how it works if you ask questions in the room. While we wait, since I'm presiding over this debate, I have a first question for both advocates, actually, so for both Mr. Tivadar and Ms. Adekoya, which is this. If you are thinking or considering establishing specialist construction courts, you then have effectively two models. So one model is the TCC. The TCC, by the way, to be precise, will be 150 years in 2023. So if you count the official referees plus the TCC is 150 years, and we'll be celebrating that anniversary in London, in England, next year. But one model is the TCC, which is basically part and parcel of the ordinary court. Yes, with kind of some specialist procedures and guidance and case management powers, but it's part of the High Court of Justice. Okay. And then you have the model, I think Mr. Tivadar has made reference to a number of courts in the Middle East and elsewhere. You have the offshore model, right? You have a model where the specialist court is not really part and parcel of the ordinary courts, with all that it means, but is a kind of offshore jurisdiction. So there is more flexibility in the remuneration of judges, appointment of judges, procedures, choice of law, and so on and so forth. So I would like both advocates, so first Mr. Tivadar and then Ms. Adekoya, to address this point and see whether what do they think about it and whether it in any way changes the balance of their argument, very briefly, while the audience are thinking about their own questions. Mr. Tivadar first, over to you.
It does not change my argument. In fact, I would say that it supports my argument, which is how you set up a specialized court is completely dependent on the needs of your own country. So I think it is inevitable that smaller jurisdictions will perhaps go for the second model. And I think the main example of that is the Dubai courts, where the courts are set up in an economic free zone, and they don't even apply. They sort of apply a common law type of law, and that I would envisage the reason for that, or the thinking behind that, was that they want to attract exactly the sort of clientele that they want to attract, namely ones who are engaged in the Middle East, but not only in their own jurisdiction, and they want to set up a court that deals with perhaps regional disputes. So I think it very much depends on the size of the economy, the size of the country, and the number of construction disputes that you think will originate in your own jurisdiction. So if you're sitting somewhere where Ms. Adekoya is sitting, I think the question is very different to when you're sitting where I'm sitting in Harare, Zimbabwe, which is a much, much smaller jurisdiction, and perhaps is not even going to be able to produce the amount of expertise in sufficient numbers. So it would always be dependent on the importation of judges, whereas bigger jurisdictions, South Africa or Nigeria, would be able to go more for the TCC model.
Ms. Adekoya.
I don't think it changes my position or my argument. When the Dubai courts were set up, they were set up against the backdrop of the extensive amount of construction that was going to develop Dubai at the time, and the need to provide a satisfactory means of resolving disputes for the international contractors who are coming in to build Dubai. I agree with Daniel that it does depend on the country and the economy. I do not think that there is any African country that would have the amount of resources that would go into setting up a construction court outside of its national court system. With the growing tide of nationalism all around the world now, I do not even think that this is an idea that is sellable to any government at this point in time, to set up a court system that has as its laws of countries other than the country where the court is located, and will bring in judges from other jurisdictions and other countries to sit as judges in those specialized courts. I look at the African Continental Free Trade Agreement, which is currently discussing its own dispute resolution protocols. And even within the context of the African Continental Free Trade Agreement, where the issue of an African investment court is being discussed, I do not see that court as getting as much traction as one would have expected. And therefore, even an African construction court to listen to and hear disputes that arise out of African countries and international investors, I am not sure would be a successful venture. So whether it is a construction court within jurisdiction or it is an offshore type of court, I still do not think that it changes my views. I still think that international contractors will still opt or are still better suited by having their disputes resolved by arbitration.
Thank you very much, Mr. Adekoya. I do wonder whether there are questions from the audience. I can't see the room, so Mr. Adekoya, you can. Anybody there?
I think everybody's thinking of their cocktails or their dinners.
Yeah, well, I have one last question then, so let me abuse my position.
There's a question online. Do you think that specialized construction courts might foster representation of Africans in African construction disputes? A robust construction court might prevent such disputes being outsourced to global arbitration hotspots, for instance, London or Paris.
So that's, I think, Mr. Adekoya, is first a question to you probably. I mean, because you have been arguing for arbitration, but don't you think that arbitration has that risk a little bit, and therefore courts would have the benefits that Alexander Kalish raises there?
I'm not sure as to whether a robust construction court will prevent the disputes being outsourced, because the disputes that are currently being outsourced on the basis of foreign counsel. And if we have a robust construction court, if that construction court is still going to have foreign counsel appearing before it, I see no difference between the present system of arbitration and the issues that arise and a system that arises out of this construction court. I don't see it as in any way stopping what is seen as African dispute flight outside of the continent to Europe.
Mr. Tivadar.
Yes, well, rather unsurprisingly, I agree with the comment here, or what I understand is the thrust of the comment. And I think this is exactly the last point that I finished my first set of submissions on. Of course, it is the case that because the courts are not sufficiently enabled, but both in terms of technology and resources on this continent, that even arbitrations taking place in this continent are very rare for major arbitrations. And the reason for that is that even if the parties choose arbitration rather than court litigation as their preferred dispute resolution process, they still need the arbitration to be seated in a venue where they can trust the underlying enabling legislation as well as the courts that will enforce it. And that is exactly why those two cities in particular, as well as Switzerland or Singapore, are extremely attractive venues. Because if you have your arbitration dispute in London and you need some assistance from the courts, as I've mentioned earlier, you get to go to the TCC, because that specialized court is not only dealing with construction disputes as a primary fact finder, but also as an enforcement mechanism.
Yes, but I mean, there is a point there, though, that arguably, because in their supporting or reviewing functions, courts don't really look at the merits of the case. So you don't really need a specialist court, do you, to deal with enforcement or appointing an arbitrator or issuing a freezing injunction, Mr. Tivadar, don't you think? Would you agree?
Well, so I think on a level of arguments, that may well be the case. On the level of practice, that is certainly not the case. It is exactly the judges who do not understand how arbitrations work, who do not understand how FIDIC contracts work, and so on, are exactly the types of judges who will interfere to an extent with the arbitration process that more developed jurisdictions would never allow. And the jurisdiction where I practice in Zimbabwe, that is exactly the case. So the biggest problem that the arbitration community faces in this country is that the courts are overly, they interfere way too much, and especially in construction disputes, because there isn't that understanding, that expertise that would make them understand why they ought not to do that, or why certain points were decided the way that they were. So I don't think that that's a valid point in my experience.
Thank you. Now, there is a point raised by Dennis Onwonga, that is, what is your view on having the option of both specialized construction courts, mostly for local construction contracts, and the parties having the option to go for arbitration when needed, especially if the underlying contracts are cross-border? I think neither party has really argued for the abolishment of arbitration, or for the making arbitration unlawful or prohibiting arbitration. But what do you say to that point raised by Mr. Onwonga? Ms. Adekoya, you first.
From the perspective of Nigeria, where we have courts with specialized jurisdictions, not so much specialized courts, but we have specialized jurisdictions in terms of subject matter jurisdiction in our federal high court, and in our state high courts, we have divisions. So we have a commercial division, a probate division, and things like that. I think that to that extent, those quote unquote specialized courts already exist. As to the issue really is as to whether we want a court in the context of what the TCC is in London, which would be a totally different structure within the court system. If it is, and we've all agreed that nobody is saying that arbitration should be abolished. And we're also nobody is saying that parties should not be allowed to put in arbitration clauses. And therefore, my position would be, we'd have to wait and see.
Thank you very much. Mr. Tivadar, any comments on that?
Well, just to say that what is described here is exactly what I would be arguing, and I have been arguing in favor of. I've started, the very first point that I made is, I readily accept that for certain parties, arbitration is the right way of going. And as Ms. Adekoya has also said, I'm not arguing that parties should not be allowed to arbitrate. The specialized court, I would view as an option that is available to the parties, and a viable option that is available for the parties as a primary court and dispute resolution body that they go to, i.e. as a first instance court. But it is also a court that is essential to ensure that if the parties choose to go to arbitration in that particular jurisdiction, that arbitration process will be properly supervised, assisted, and ultimately enforced. So there's nothing in this comment that I would disagree with. In fact, that is exactly what I would be contending for.
I think there is a point, though. I mean, both of you have insisted on the word suited, and I think both of you broadly agreed that setting up these courts would not be an easy exercise. So would require time and effort and money, fundamentally. So I guess there is a point. Of course, in theory, why not have a specialist court? And of course, parties will always retain the right to agree to arbitration. You just give an extra option, fundamentally, and if the parties like it, they'll go for it, and if not, they'll go for arbitration. But because of the time and money and effort that these courts require for setting up, and also because you then don't want a court to be there sitting without enough business, without enough workload, then really, I think, and that's where our debate, I think, becomes real. I mean, it becomes practical in a sense, for policymakers, for lawyers, and everybody engaged in, policy making and in reforms in Africa. But, the same problem may apply, to Italy, to Latin American countries, etc. I mean, the point is, would parties then really go to these courts and therefore forgo arbitration, so that these courts are worth setting up, so that they have enough business, and they do build an expertise, and they do build a body of precedent, and they do attract good judges that then over time, they have, hopefully when they join, but then over time they strengthen and refine their expertise. Otherwise, then you basically just go through an expensive exercise, and you will have an institution that may have a few cases and some very intelligent construction lawyers as judges, but then was not really worth the effort. So Mr. Tivadar first, I guess it's a question for you first, and then to Ms. Adekoya, whether she has anything to add. And then if there are no further questions, we move on to conclusions, rather. Mr. Tivadar.
Yes, I mean, I would start by saying that the point that you make, Professor, is absolutely valid. There's no point in setting up these courts unless they are properly utilized. However, for them to be properly utilized, they have to be set up properly. And what my argument is that as long as we make the effort, and this is why I emphasize the amount of time, planning, and money that would be required. I'm not shying away from that. But if we get that right, then in my opinion, the system would be very much utilized. And perhaps we can look at the experience of other specialized courts that have been set up recently. So if we look at the DIFC, the Dubai court, that had an increase of 72% in claim value between 2019 and 2020, and it's standing just below, I think, $3 billion now that were claimed in just that 1 year, which is an over 70% increase. So we have to get it right. But for me, this is analogous to saying, well, do we need a train system in the country when everyone is on bicycles? And then someone saying, well, it would be a massive investment and perhaps no one will use it. Well, if it is done properly, we know as a matter of fact that people will use it. If it's done incorrectly and priced incorrectly and doesn't go to the right places, then of course it is not going to be utilized. But I wouldn't throw out the principle just because it may be set up, it may be materialized in a way that is incorrect. I would rather spend the time planning it so that the rules are properly done, the court is properly staffed, and the judges are properly remunerated, as Ms. Adekoya has properly pointed out.
Thank you. And then to you, Ms. Adekoya, the way I would put the point to you is, Mr. Tivadar says that if the system works properly, we know it will be utilized. Do you agree with that statement?
It's a tough one. I agree that if we're going to set it up, it must be properly set up. It must be properly staffed. It must be properly financed so that it attracts business. Otherwise, it's a waste of government resources. In terms of domestic disputes, I would tend to feel that if it is properly set up and properly staffed with knowledgeable, acclaimed expertise available, then domestic construction disputes may find their way there, and there would probably be, over a period of time, less inclination to put arbitration clauses in disputes between domestic parties. In respect of international disputes, I still have my doubts as to whether, no matter how well staffed, how well resourced a construction court is, whether that would shake the views of international investors who do not really want to engage with domestic laws unless it is at an enforcement stage.
Thank you very much. Now, this brings us to final submissions by Mr. Tivadar first, and then by Ms. Adekoya. 3 minutes. Mr. Tivadar, over to you.
Thank you very much. I shall be brief, but I think my main message is let's not give up on Africa, let's not give up on the continent, because I hear all the difficulties that Ms. Adekoya has absolutely properly mentioned. But I say that we mustn't allow the status quo, the status of the judiciary, the status of the legal infrastructure that many African countries currently experience. Let's not allow that to make us reach the wrong conclusion and sort of give up on the system, because the system is very much needed. It is a system that has worked in other jurisdictions, and it is a system that, in my view, if done properly, can have ripple effects in other areas of justice delivery as well. So if you have a perfectly well-functioning construction court, then I wouldn't be surprised if other areas of the High Court or other judges of the High Court would be looking at that functioning court and thinking, what is it that we can do so as to enable us to be more efficient and work better. So for those reasons, I would invite you or the audience or whoever it is that is going to vote to be in favor of the motion. Thank you very much.
Thank you very much, Mr. Tivadar. Then to you, Mr. Adekoya, for final submissions.
My final submissions will definitely not take me 3 minutes. I will merely reiterate that what we are arguing is not whether we should have one system or the other, but whether the system of specialized construction courts are better suited to the resolution of African disputes rather than recourse to arbitration. I believe that I have highlighted all the reasons why specialized construction courts are not better suited. There's a staffing issue, there's a funding issue, there's an ownership issue, all of which will affect the credibility of the courts when established. And until those issues can be resolved to the satisfaction of the disputants, who are the ones that we want to use these technology courts, then I think that arbitration is better suited to the settlement of construction disputes in Africa than the establishment of specialized construction courts.
So thank you very much to both Mr. Tivadar and Ms. Adekoya. Now we now come to the voting. And so all I can do is to declare voting open. I hope that the organizers have told you how to vote, because of course our advocates, Mr. Tivadar and Ms. Adekoya and myself cannot vote, but you can. And so please proceed to do so.
So I think I have been allowed to vote. But
have you? Okay.
I'm going to refrain.
Then that's interesting. So So the poll is on, so you can all vote.
The poll is on. For those of us in here, I think we'll just take a hand count and then add it to whatever results we get virtually. So if you are for specialized construction courts, please can you just by a show of hands? All right. Are we taking the count? Please, let's take the count. So we have one hand here. Okay. If we are not for specialized construction courts, can you please? Okay. Yes, please. Great.
1, 2, 3, 4. 5, 6, 7, 8, 9, 10, 11, 12, 13, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 31, 32, 33.
No. So, Prof, each
Yes.
person here, we have about 33 hands not in favor of specialized construction courts.
Okay.
And then I think we had about 3-4 hands. No, we had three. We had three hands in favor of specialized construction.
Thank
courts.
you. Thank you.
I believe you can see the polls and the polls for the virtual counts, and you can make the announcement.
Yes, I can. I can see mine. But, let me see.
Yes.
So can we close now the poll? Can we end the poll?
Yes. Can we end the poll, please?
Because I think when we so we have online 10 against and 6 in favor. So it's clear that the motion has been rejected by 43 votes against the motion, and we have had 9 votes for the motion. So well done to Ms. Adekoya. Obviously, that really doesn't come down to, or not necessarily only to, the advocates. I think actually we all agree, obviously, that both Funke and Daniel have been extremely competent and intelligent speakers, making the right points on both sides of the arguments. I do think I have voted also against the motion, and and since speakers and the chair could not be allowed to vote, I was indeed allowed to vote. I thought I wasn't. It wouldn't have made a difference anyway. But I think there is, especially, I think in principle it's a good idea to have specialist court and give parties the choice. I once again hear a terrible echo. But anyway, the very short point I wanted to make is that in principle, of course, it's good to have specialist courts and have a choice, so that parties can always have a choice between a specialist court and arbitration. I think, and of course, the other obvious point is that this comes down also to individual countries, because a specialist court may work very well in Nigeria and perhaps not so well in Zimbabwe, and we can really go country by country, and this really obviously this is a Pan-African, if I may say, an Africa-wide conference, so we have to frame the question as related to the entire continent. But of course, this may well be a choice. It is going to be, after all, a choice, country by country. But what's key to me is really do we have the resources, the right specialists, the money to set up a court? This is not going to be easy. There is no point in setting up a specialist court if you cannot staff these courts with very good construction lawyers and specialists, basically. No point if the court, doesn't work very well and has the facilities and the premises and the administrative support and clerks and so on. And then the question is, once you have set it up, will it have enough business really to work? But we don't know why there was a majority against the motion. That's I think something that you will discuss over your networking session and drinks, which unfortunately Daniel and I are not going to be able to enjoy. I think before that, I would just like to ask you to thank Funke and Daniel in the usual way. I think we can you can certainly clap from the audience. They're live. I think our speakers have done a wonderful job, really bearing witness to their huge expertise in this area. We should say that Mr. Daniel is also very much a litigator, etc. So he has a slight conflict of interest there, and Funke is very much an international arbitrator now. So they were quite naturally on different sides, but Daniel also has a huge practice in arbitration. So very interesting. I am sure this debate will continue over drinks, but also over the years, because it's a very real and important debate. I just conclude by myself thanking the organizers, HKA, Seika, Go, and everybody who has really made this conference possible. King's College is one of the many supporting institutions. We have been supporting Africa construction law almost from the beginning. We will continue to do so. We hope, myself and some of my colleagues, to be able to come to Nigeria and other African countries very soon. Other than that, enjoy yourselves, and we are very envious that we cannot really join you in person. Thank you.
Thank you very much, Prof. Thank you, Dan. Thank you, Mrs. Adekoya. Thank you very much. Thank you. Please, another round of applause. So at this point, after many engaging sessions today, we've come to the end of today's session. We have another day tomorrow, and we'll be starting, so the arrival is at 8:30, and we hope to kick off around 8:45 tomorrow. Thank you very much for staying up until now. Just before you leave, we have cocktails and networking drink outside. So please let us have those conversations over drinks. Thank you.
Let me just put this in. And let me just press that.
I'm not trying to be funny, but I left it all at home today. You can call me what you wanna, I ain't giving you $1 this time, I ain't gonna run away. You might knock me down, you might knock me down, but I will get back up again. You can call it how you wanna, I ain't giving you $1 this time, I ain't gonna run away. This time, this time, this time, this time I ain't gonna run away. Not this time, not this time, not this time. This time I ain't gonna run away. Sorry, I ain't got no money. I'm not trying to be funny, but I left it all at home today. You can call me what you wanna, I ain't giving you $1 this time, I ain't gonna run away. You might knock me down, you might knock me down, but I will get back up again. You can call it how you wanna, I ain't giving you $1 this time, I ain't gonna run away. This time, this time, this time, this time I ain't gonna run away. Not this time, not this time. This time I ain't gonna run. Not this time. This time I ain't gonna run away. Lift my heart up when the rest of me is down. You entwine me even when you're not around. If there are boundaries, I will try to knock them down. I'm letting on, babe. Now I know what I have found. We feel we're close and